Hello friends, this is lecture number 13 of Criminal Law Basic Concepts. This is a part of Clat lecture series. These classes are sponsored by Sri Jendra Rangzon. I am your mentor, Shekhar Gehlot. Okay, so we are now, let's go to another part, or which I may say the last part of our criminal law series. Okay, this is the part which deals with offenses against marriage. Okay, now we have done offenses against the human beings and sexual offenses, offenses relating to obscenity, and now we proceed to offenses against marriages or offenses against a marriage. Now let us see what are the offenses against marriage. First is a mock marriage. Mock marriage. Now you must have heard this word such as mock test, mock trial, etc., mock experiment, etc. The word mock means a sham. Okay, a sham or a type or resemblance, but not reality. Mock is something which is not real, but it may resemble a real. It is a sham. Ultimately, it's something which is sham, or it is just type of thing, or it resembles that thing, but it's not really that thing. So, first offense in the offense against the marriage series is mock marriage. That means a sham marriage, marriage which resembles a marriage, but it is not actually a marriage. Okay, here what is happening? A person is contracting a mock marriage. A person is contracting, let us not say contracting, let's say performing. Contracting is a bit controversial. Okay, but though in India now marriages are more like a contract. A person is performing a mock marriage. That means he is performing a marriage with someone which is a sham. Okay, which is not a real marriage. While the other person believes that the marriage is real. Okay, while the other person believes that the marriage is real, and one of them knows that I am conducting a mock marriage, I am conducting a sham marriage. So, what will happen to such a case, and why someone will contract a mock marriage? Probably for property, or maybe for sexual pleasures, okay, or maybe any other reason, okay. Excuse me. But in the law, we in law are least bothered about why somebody contracted a mock marriage. We are more concerned with whether someone has performed a mock marriage or not. If someone has performed a mock marriage and the other person who has led the other person to believe that the marriage is a real marriage but actually it's a mock marriage, that conduct is punishable because marriage is to be treated seriously. Man deceives a woman to think that both are lawfully married and cohabits and has sexual relation. This section has been generally covered under section 375 4.3, which deals with rape. So this is also a kind of rape. Okay. But this is a separate offense as well. So if someone who deceives a man who deceives a woman to think that both are lawfully married and cohabits and then has sexual relation with the woman, okay, then he will be punishable under this section. Under this section as well as under section 375. Okay, but the typical thing with this section is that it begins with the word man deceives woman to think. That means in this case, a case of mock marriage can always be filed only against a man and not against a woman, because the law says man deceives a woman. Okay, just a minute, please. Yes. So, law says a man who deceives a woman to think that both are lawfully married and cohabits or has sexual relation with a man then is guilty of conducting a or performing a mock marriage. But the typicality of this section is that we believe only a man can commit a mock marriage, and we can punish only a man, not a woman. Okay, we can punish only a man and not a woman in this section. Only man is to be punishable, probably because when this law was enacted, section 493 was enacted probably 100 years back, that time it was only the man who was performing sham marriages. Okay, now the situation is not that. Okay, it is now both the sexes have equal rights and equal powers. But anyhow, the section says so. We have to read the words like this. Anyone who performs a mock marriage shall be guilty Okay, that means anyone who will conduct or perform a mock marriage, he shall be guilty for at least for up to 10 years of imprisonment. Okay, so this is the first offense against marriage, mock marriage. Then we go to bigamy. Bigamy, or we may write it like bigamy. Okay, bi means, this word bigamy means, bi means two. Okay, gamy is a root word for marriage. Bigamy means having second marriage or marrying more than once. Marrying more than once or having second marriage. Bigamy is offense of bigamy is having second marriage. Let us read what section 494, which deals with bigamy, speaks. Bigamy, marrying again during the lifetime of the spouse unless marriage is annulled by court of competent jurisdiction or the spouse is missing for more than 7 years. Okay, so it says if you marry again, okay, if you marry again when your husband or your wife is already alive, when your husband or wife is already alive and you have not taken a divorce, okay, you have not taken a divorce, you may be living apart from each other, okay, you may be living apart from each other. That is not issue. Issue is that you cannot remarry till the time you have not taken a divorce from the earlier spouse, or your earlier spouse has died, or your earlier spouse is missing, has not been heard for 7 years. Earlier spouse means earlier wife or husband. Okay, but if your earlier spouse is alive and you know that he is alive and she is alive and so on, and then you again go for a second marriage, we do not allow second marriage. Then one may be sentenced for up to 7 years in jail for committing second marriage. Okay, for committing second marriage while the earlier wife or husband is alive. However, this is subject to religious practices, like Muslims in India can have 4 wives at same time, but wife cannot have more than one husband. So, a Muslim male in India is allowed to have four wives at a time, but a Muslim wife or Muslim female is not allowed to have more than one husband. So, this law of bigamy will be applicable upon the Muslim wife, Muslim female, but will not be applicable upon the Muslim male because he is allowed to have four wives. But yes, if he takes a fifth wife, then he will be definitely guilty of bigamy, and all other religions usually allow only one marriage, and if the marriage is subsisting you cannot contract another marriage meanwhile. Now let's go what section 495 says. Whoever committing bigamy conceals from the spouse of subsequent marriage about his former marriage, more aggravated form of punishment. Now, if someone is committing a bigamy, someone is committing a second marriage, okay, a man or a female, they are committing a second marriage with other, but conceals this fact. A man, suppose a man who is already married, he marries another woman, okay, but he conceals this fact from the new spouse that he is already married, then it is a more aggravated form, then more aggravated form of punishment will be given. That will, oh, what is this? That will go up to 10 years in jail. Okay, now if you are committing a bigamy, it is 7 years, but if you are committing bigamy and at the same time you are hiding it from the new spouse, then you shall be liable to be sent behind the bars for up to 10 years, as the case may be. Okay. Section 496. Whoever goes through a marriage ceremony knowing that he is not allowed, although the section does not talk about man and woman categorically like section 493, but the intention of makers of the legislation was to punish a man for such crimes, women cannot be punishment under it. Okay, section 496 is punishment for 495 or 494. Whoever goes through a marriage ceremony knowing that he is not allowed, then he shall be punished. Okay, this is the punishment. Now the next offense against marriage. Please excuse me for a minute. Criminal elopement. Okay, elopement means taking away. Okay, criminal means with bad intention. Section 498 says detaining a married woman with a criminal intent to have illicit sexual intercourse, willingness of wife is immaterial. Okay, it says simply detaining a married woman with a criminal intent to have illicit intercourse. You have taken away someone's married wife, someone's wife with you, and someone has intention of having illegal sexual intercourse with her. It is punishable. Willingness of wife is immaterial even if wife says that sexual intercourse has taken place due to consent. It will not be a valid case and you shall be guilty. But anyhow, now this section is no longer operative and as per Supreme Court judgment, relations established by choice between two adults, whether married or not, are not punishable. Okay, so earlier this is the law, but now Supreme Court says if the willingness of the wife is now material. Earlier it was immaterial. Earlier it was immaterial whether wife willing to have sexual intercourse outside her marriage or not. Now it is material if wife willingly has sexual intercourse outside marriage with some man, then there is no offense at all. Okay, then there is no offense at all because the Supreme Court says relationship established by choice between two adults, whether they are married, okay, or not, are not punishable at all. Whether they are married, that means whether they are married to each other or not, or whether they are married to their respective spouses and then they are establishing those relations, then also it is not a punishable act anymore. Next offense is offense of dowry. When we are talking about offense against marriages, offense of dowry, this is section 498. I am writing all these sections only for a reference purpose. You are not required to remember these sections. Okay. So dowry, what is dowry? What is dowry? Dowry is a criminal practice where a groom seeks or groom's family seeks cash, gifts, donation, land, and etc. by from female family, from the family of the bride in lieu of the marriage that we will complete the marriage or we let the marriage get completed only if some cash or this and that or gift or bike or car or a bed or whatever is gifted. This is the criminal practice which is followed in India, particularly in northern India, states of like Punjab, Haryana, Uttar Pradesh, etc., Madhya Pradesh, Rajasthan. Okay, in these places, this offense of dowry is rampant. Okay, so that is why we have a section which talks about dowry prohibition. Okay, section 498A. Dowry is an offense, so that is why we should reword the section as dowry prohibition. Dowry prohibition. Now, what this section says, let us read it carefully. Husband or relative of the husband of a woman subjecting her to cruelty. That means we are talking about a woman, and who can subject this woman to cruelty? Husband or relative of the husband. Husband or relative of the husband of a woman subjecting her to cruelty. They are subjecting her to cruelty. Whoever, being the husband or the relative of this is the title of the act. Section, sorry. Whoever, being the husband or relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years, and so shall also be liable to fine. Now, what is cruelty? Okay, when it says husband or husband's relative subject women to cruelty, the law defines cruelty as well. What is cruelty? Cruelty is any willful conduct. Willful means you are willfully, by choice, someone is doing it. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. Like you are behaving in such a manner, you are such cruel to her. We are not concerned whether the cruelty is physical or mental, but there is cruelty to the woman, and cruelty is such that it is likely to drive the woman to commit suicide. Like your conduct is such that it may drive a woman to commit suicide or cause grave injury or danger to life. Or she may, in an attempt to commit suicide, she may cause grave injury to herself. Suppose she is upset with you people and she is jumping from the roof. Now she jumped from the roof. She didn't die, but she has caused grave injuries to herself because she has survived. Or she is causing danger to her life, limb, or health, whether mental or physical, of the woman. Whether there's a mental pressure to the woman, women is being driven to depression because you people, or husband family, is constantly punishing her and treating her with cruelty for demanding dowry. Okay, this is what the cruelty the law says. Or harassment of women, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. You are making such demand from the wife, okay, because her family or someone related to her family, they have not given you sufficient gifts in the marriage. That is the offense against marriage in the law. Okay, this is what we are talking about, dowry prohibition. This is what dowry is, but we have to read one keyword, that is whoever, being the husband or the relative of the husband of the woman. That means the people who could be held guilty. Okay, only husband or the relative of the husband of the woman can be held guilty under this section. That means if a friend of husband asks for dowry, he shall not be held guilty. Why? Because the act says husband or the relative of the husband. Friend definitely is not the relative. Friend definitely is not the relative. Okay. So this is the Dowry Prohibition Act, and this is how we are dealing with the meanness of dowry in the society through the instrument of the law. Okay, now let's proceed to another category of offense. Offenses against the property. Now we are done with offenses against human body. Okay, offenses having sexual undertones, offenses which are obscene, offenses relating obscenity. Okay, offenses relating to marriage, and now we are going to discuss offenses against property. Okay, offenses against property. First is theft. First is theft. What is theft? You all understand theft. I'll just give you a general explanation of theft is. Theft is usually, or sorry, in general terms, we can define theft as an act of stealing. Section 378 says, Section 378 defines theft. Theft. What is theft? Let us read. Whoever intending to take dishonestly. Whoever intending, that means intention is compulsory. Mens rea. Guilty intention is compulsory to commit theft. Which means innocent taking of property, not a theft. If someone innocently takes a property belonging to someone else, it won't be a theft. Theft is only when someone is intending to take dishonestly any movable property. Then the next thing is that theft could occur only in respect of Theft could occur only in respect of movable property. Okay, no theft could be against an immovable property. Okay, there cannot be a theft of immovable property. Theft can only be of a movable property. Whoever intending to take dishonestly an immovable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Okay, now what is theft? How it is defined in the law? Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent. Now you are taking the property out of the possession. Someone is having possession of the property. We are not talking about ownership here. Okay, possession and not ownership is the key. Okay, my friend Sumit has a computer which is presently with me. Raju comes and illegally takes the computer out of my possession. He is guilty of theft. Okay, because we are talking about possession. Law talks about possession. Law is not talking about ownership. If it talked about ownership, then if somebody would have taken the property from me, it would not have committed theft. Why? Because I did not have the ownership of the laptop. Sumit had the ownership, and when the laptop was taken from me, I was not the owner of it. So we are not talking about ownership. We are talking about possession. Even a property can be stolen from a thief. Okay, that means a thief. I am assume a thief. I stole a laptop from someone. Now the laptop is in my possession. And if someone is stealing the laptop from me, he is also committing theft. You cannot say that because he is a thief, he has stolen it from someone else, we'll steal from it. That will also amount to theft. Stealing from a thief is also theft. Okay, so you take any property, okay, whoever intending to take dishonestly an immovable property out of the possession of any person without that person's consent, okay, without the person's consent, moves that property in order to such taking is said to commit the theft. Moves that property. Okay. Mere moving the property with the intention to illegally take it out of the possession is sufficient. Even ultimately, one may not be able to take the property out of the possession, but simply because he has attempted to move the property with the illegal intention, with the dishonest intention of moving the movable property out of the possession of someone without his consent, the offense of theft is complete. Okay, now let us read this section again and you will understand what theft is. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Mere moving is sufficient. Okay. To commit theft, the property must be movable and should be in the possession of that person. Thus, it is not an offense against ownership. Taking it out of possession must result in wrongful gain of one and wrongful loss of another. The taking, loss, or gain may not be permanent. Temporary removal can also amount to theft. Every property is movable except. Now, what is movable property and what is immovable property? We have discussed it in the case of when we discussed um, contract act. When we discussed contract act, okay, then we discussed movable property, but let us now again discuss it. Every property is movable except land and things attached to, sorry, sale of goods act we discussed. You can refer to sale of goods act for getting the what is movable and immovable in terms of sale of goods act. For the IPC, let us read: every property is movable except land and things attached to land, or permanently fixed to something. So every property is movable which is not attached to land, or which is not permanently fixed to something which is attached to land. Tree is attached to land, but as soon as you cut it with a dishonest intention to remove it from the someone's possession, it is no longer attached to land and the act can qualify as theft. So now the tree is attached to land. It is an immovable property. You cannot commit theft of it. But the moment you cut it, okay, it becomes a movable property and now you are guilty of committing theft. Electricity is not movable property under section 379 but theft of cooking gas, water, etc. The consent here may be expressed or implied from the person with whom the possession of property lies or who has the authority to give such consent. So consent of taking the property may be expressed or may be implied as well. There can be no theft where there is no dishonesty. That means, like we discussed, innocent taking away of property is not a theft. Okay. There can be no theft where there is no dishonesty. Larceny under English law. Theft is called larceny under English law. Property must be owned by the person. Okay, now we are not going to English law. Extortion, section 383, 384 of the IPC. We have done theft. What is theft? Now let us do what is extortion. Okay, you must have heard it in the newspaper a lot of times that you must have heard it a lot or read it in the newspapers or somewhere else that some gangster is asking money from some builder, movie producer, financer, etc. Okay, this act of asking money, this act of asking money is called extortion. In the legal term for this kind of act is extortion. Okay, now you understand what is extortion. Let us read how IPC deals with this term extortion. Section 383 extortion. Intentionally putting a person in fear of injury to himself or another. You are intentionally, okay, that means mens rea is required now. In most of the offenses, usually mens rea is required. Some exceptions are there. One of them is kidnapping. Intentionally putting a person in fear of injury to himself or another, dishonestly inducing a person to put in fear to deliver any person, property, or valuable security. That means you are doing something in which you are putting someone. Simply saying, putting someone or any other person in whom this person may be interested in fear of injury if he does not deliver that property, cash, or documents to you, something like this, that is called extortion. Okay, this is extortion. Fear of injury must be real to unsettle the mind of person. Fear of injury must be real. Okay, it cannot be an imaginary fear of. It cannot be an imaginary fear. So when I make a call to someone that I will put you through injury if you don't give this to me, there is no threat at all. There is no fear of injury at all. But if a gangster is calling, then everyone knows that gangster is competent. He can get it done. So when gangster calls, the fear of injury becomes real. or when a normal person like me would call the fear of injury will not be real, or a person may be actually standing nearby and holding a gun or a weapon, then the fear of injury will become real. Or if I simply go walk into someone's office and say that give this thing to me, otherwise I'll beat you, and he hands it over that thing to me, then the fear of injury will not be real and there will be no case of extortion. Okay, so it should be real in such case that it unsettles the mind of person to whom this particular thing is being conveyed. Fear not necessarily be physical injury. Injury to character may also be injury. Fear may not be of physical injury. Injury to character, okay, like blackmailing. Injury to character now is blackmailing. Blackmailing someone with information, photos, or videos you may be having about someone, some confidentiality which, if declared to the public, will lead to the character assassination of the person concerned. Okay, this can also be a real threat. Then, if you are saying to someone that I'll put your video, photo, info in the public domain, or I'll tell it to your family or husband, otherwise you give it to me, give this thing to me, then it will be extortion. There runs a principle of vicarious liability. If some uses force and other receives the property, all would be guilty of extortion. Now, the principle of vicarious liability is applicable in the case of extortion as well. That means the gangster is calling from Dubai. Okay, in Mumbai, gangster calls from Dubai and makes a call from Dubai to Mumbai, and someone is receiving the property from Mumbai. Okay, gangster calls me and says deliver it to the person who is wearing red jacket, and I go and give this money to the person who is wearing red jacket. Both are vicariously liable, both are jointly liable for the crime of extortion. Threat of criminal charge, whether true or false, amounts to extortion. Threat of a criminal charge, whether true or false, amounts to extortion. That I will file a legal case against you if you do not pay my money. I'll file a false case of rape. File a false case of beating me. I'll file a false case of attempt to murder, etc. All these things, if you don't give it to me, all these things amount to extortion. Any kind of blackmailing, which is real blackmailing, which has the effect of unsettling the mind in lieu of some property, valuable security, or cash, or etc. It all becomes extortion. Threat to expose a bishop of his illegal relation was considered extortion. So a bishop, definitely they are unmarried. So you are threatening a bishop that I will reveal your illegal relation. If you don't do that, definitely bishop has a reputation to keep, and that is going to be character assassination. So bishop is now afraid. That is a real threat. That is extortion. Threat of law for blackmailing is criminal. Okay, threat of law for blackmailing. Threat of law for blackmailing, like police officer goes to someone and says, will file case against you if you do not give that property to me. Okay, then this is a threat of criminal charge. Now, police officer may file a real case or may file a fabricated case. He has a power. Okay, so it is this threat. When property or document is obtained by such means, it is extortion. For extortion, there must be fear and delivery of property. Okay, now for the offense of extortion, there must be fear and delivery of the property as well. Okay, forcibly taking signatures don't amount to extortion. As in extortion, there is a sense of consent, although not free and given under threat. So something which is done forcibly will not become extortion. Extortion is okay. Whether sorry, extortion is where other person himself delivers that thing to you. That thing means property or cash or something else to you with his own consent. However, such consent is obtained by fraud. Okay, there is essence of consent. Okay, consent is the essence of extortion, that someone consensually gives it to you, although not free and given under threat of fear. This distinguishes it from theft too. Okay, because otherwise it will be a case of theft. When you are taking someone's property without someone's consent, that is theft. Okay, that is theft. But when you are someone himself is giving you his property, that is extortion. There is no consent of honor in theft. Property is only movable, no element of force by the accused, no delivery of property by the owner. These are the theft we are discussing. Okay, this is the theft. While in cheating there is consent but obtained through fraud. In extortion it is obtained through fear. Okay. Property involved in extortion is both movable and immovable as well. You can take the immovable property as well by extorting someone. Now what is robbery? What is robbery? Okay, so robbery has no such definition in the law, but we can understand robbery or we can define robbery in two ways. When theft is robbery, when extortion is robbery. Now we have read the theft, we have read the extortion. Now let us read what is robbery as aggravated form of theft or extortion. Okay, the robbery is aggravated, more severe form of theft. Sometimes robbery is more severe form of extortion. Now let us read. Robbery in common language means to deprive a person of his or her property. The chief distinguishing element is the presence of imminent fear of violence. Okay. In all robbery, there is either theft or extortion. In all cases of robbery, either there is theft when theft is robbery, or there is extortion when extortion is robbery. When theft is robbery, when theft will become robbery, when we will call an act which otherwise amounts to theft as a robbery. To commit theft, while committing theft, carrying away or attempting to carry away the property obtained by theft, if a person voluntarily causes or attempts to cause death, hurt, wrongful restraint, fear of instant death or instant hurt or instant wrongful restraint. Okay, now this is simply it says when theft is robbery, like we discussed, theft is moving the property away from without someone's consent. But you, while not you, sorry, but one while committing theft carries a gun with order to kill or shoot someone if resistance is offered. See, I'll give you a small example. Three burglars enter a house in the midnight. Now they commit a theft, they take all the valuable equipments and run away. That is called theft. But now these three burglars enter a house, they are carrying weapons. Someone is carrying a knife, one is carrying a dagger, one is carrying a pepper spray, other one is carrying a gun. That if someone comes, some of the family member wakes up, will kill him or shoot him. Okay. And also sometimes, meanwhile, they hurt someone. Suppose someone is awake. Someone has woken up. They shoot him in the leg or give him a cut by the knife or beat him or do something like this. Or I am going with my car. I am driving my car on the highway. Someone stops my car, puts a gun. Okay. And takes the car. That is called robbery. When your theft is done with causing danger to someone, with causing hurt to someone by deadly weapons. Okay. Or you are causing instant fear of death in someone. How do you cause instant fear of death or hurt to someone? By putting a gun. You have put a gun, you may not shoot, but that is robbery. Okay, and that is when theft will be robbery. Similarly, when extortion is robbery, while committing extortion, a person puts a fear of instant death or instant hurt or instant wrongful restraint to that person or any other person. By such fear induces the person to deliver up that thing which is extorted. So now extortion means, like we discussed, someone is blackmailing someone that I will put your photos. That is extortion. But now you are not threatening with the photos. You are saying, I'll kill your son. Something like this. Someone is saying, I'll kill your son. I'll kill your son. And he is standing outside the school where the son is studying. And he sends the photograph as well. Now the person is immediately afraid. Okay, then he delivers the thing to you. That is when extortion will become robbery. So robbery is ultimately no offense in itself, but robbery is aggravated form of theft. When theft is done in a severely manner, when you are hurting someone, you are carrying a gun or something like this, then theft will become robbery. Or if you are committing extortion, then extortion will become robbery if your extortion is committed in such a manner, okay, that you are putting someone in instant death or instant hurt or instant wrongful restraint to that person. Okay, now let us go to section 395, 391, that is dacoity. Okay, dacoity, or you may Hindi word is dakati. Dakati or dacoity, which is five or more persons conjointly. So for dacoity, so you understand what is robbery? You understand what is robbery? Okay, now when the robbery is committed by less than five number of people, it is robbery. When it is committed by more than five number of people, robbery will become dacoity. Now let us read dacoity. Five or more person conjointly united in concerted action commits attempts to commit robbery or committing attempting to commit robbery, and persons aiding such commission or attempt is said to have committed dacoity. When there are less than five number of people, it will be robbery. When there are more than five number of people, all five may not be at the spot. Two may be assisting them from somewhere else. Four are on the spot. Okay. Or one is on the spot. Three or four, five people other are supporting him from other sides. Then it will be dacoity. When five or more people commit robbery, it is dacoity. When people less than five in number commit theft while committing hurt, it will be robbery. It is like this. Okay. Dacoity means five or more people. The more number of people, the more strict the law will be for you. Dacoity is more strict than robbery and theft. Same as robbery, except number of offenders. In many countries, dacoity is termed as gang robbery. All persons committing robbery must share common intention. If no force or violence is required by dacoits or the inmates offer no resistance, it doesn't reduce dacoity to theft. Okay, if no force is, no resistance is offered by someone, you cannot simply say that this is theft only and there is no force used, so you cannot say that we have committed dacoity. Why? Because dacoity is robbery and robbery is theft ultimately. Punishment for robbery up to 10 years and fine when committed on highway between sunset and sunrise may extend to 14 years. Okay, if it is done after setting of the sun and before rising of the sun, it may extend to 14 years, otherwise 10 years. Okay, when murder and robbery are committed, the offense falls under this section. 395 punishment for dacoity. Imprisonment of life or rigorous imprisonment up to 10 years and shall be liable to fine. So, dacoity is more severe in punishment than robbery. Ultimately, these are all robberies only, but number of people make the difference. If 5 or more, dacoity, if less than 5, are robbery. So, punishment for dacoity is imprisonment for life or RI, that is rigorous imprisonment. Rigorous imprisonment is in which you are forced to or compelled to do manual labor. Okay, up to 10 years and shall be liable to pay fine. That is it. The next is, because we are discussing offense against property. Next is misappropriation of property, section 403, and criminal breach of trust. Misappropriation of property and criminal breach of trust we will do. Okay, dishonest misappropriation of property. Misappropriation of property. Misappropriation means misappropriation. Appropriation means using it. Okay, like appropriation of money is like buying something with it or doing anything with the money. Okay, so misappropriation of money is misappropriation of property means property is used in some other way than as was ordered by its owner. Okay, then as ordered by its owner. Let us now read it, you will come to know. Whoever dishonestly appropriates, that is, uses or converts to his own use permanently or temporarily any movable property, punished with imprisonment up to 2 years, fine, or both. Okay, now let us see what is it. When the property belonging to some other person comes to one's possession innocently, but after knowing the facts and due to change in intention, if any person continues to retain the property, it becomes wrongful and fraudulent, implies that the offender must be in the possession of property and must belong to complainant. Simply it states, I'll give you an example.
It's 11 o'clock.
So these are the examples in which will help you to understand what is misappropriation of property. That is, petrol pump owner gave 20 lakh rupees to the manager that go and deposit it in the bank. Manager uses it himself. That is misappropriation. He has now misused the property. I give gold chain to my friend for wearing at a wedding. He sells it. I have given my gold chain. My friend asked me, give me a gold chain. I am going to a wedding. I want to look good. I gave my chain to him. He has sold it. My friend gave his computer to me. I sell it. Okay, like these. These are called criminal dishonest misappropriation of property. Sometimes it may be that one gets hold of a property but does not know the owner, then he could use it. But if he gets to know the owner and still does not give it back, then he is guilty of criminal misappropriation of property. Okay, then he is guilty of criminal misappropriation. Now, like suppose I am going on the road and I am traveling in the bus. I find a mobile phone. I use it for 2 days. Now, after second day, I receive a call from the owner and he says this phone belongs to me. I've lost it in the bus. Please return it to me. Now I shut down the phone so that no one can trace me and I sell the phone. That is also criminal misappropriation because now I know the owner. For 2 days I did not know the owner, then it was not a misappropriation. Okay, but now when I come to know and now I have got a fraudulent intention and then I sell it off or I use it for my personal use, then it will be a criminal misappropriation of the property. A person who finds property not in possession of another. So now someone has found a property, like I gave the example, I found a mobile phone of another and keep it with him for protecting it is not guilty. Someone kept it so that the property does not lose its value. But if he uses it, converts it for his own use after knowing the true owner or having means to discover, he misappropriates before he has used the reasonable means to send notice to owner and has kept it a reasonable time for the owner to claim it. So now he must give reasonable notice to owner, like he should get it in the newspaper that I have found this, or he should make a notice on the notice board. Okay, and he should wait for reasonably time. Like it depends, reasonable time we have discussed a lot times that it depends upon the property. If the property is perishable, reasonable time is very small. If the property is more permanent, reasonable time could be month, 2, 3, 4, 5 months. Okay, so you have to wait reasonably to find the owner. If you are not able to find the owner, you can have the property, but you have to wait for the owner first. You cannot straight away use something which does not belong to anyone. You find it and start calling it yours. Reasonable means time depend upon the facts of the case. Finder of goods can use the goods if, after reasonable precautions to ascertain the owner and keeping the good for a reasonable time, the owner is not found. But if he uses immediately, he would be liable. Okay. Now that was criminal misappropriation. Now let us do what is criminal breach of trust. What is trust? Trust is when someone has faith upon you, or someone has confidence on you, or your friend, or he has belief in you that you will do this particular thing. That is called criminal breach of trust. Okay, the accused must be entrusted with that property or have dominion over that property. Dominion means control over that property, dishonestly misappropriates or converts to his own use, or dishonestly disposes the property as against the prior contract or violation of the law prescribing that bond. Okay, that is criminal breach of trust. That is criminal breach of trust. Now, criminal misappropriation is when you have the property, you may find it, or you have taken it from a friend, or you have taken it from someone. That is called dishonest misappropriation of property. But criminal breach of trust means you are having control of the property as per part of your job. Like in the case of this bank manager, this manager has control of the money as he is the manager, so he is guilty of criminal breach of trust as well. Okay, but my friend gave one computer to me. I am not having it as a job. Okay, as part of my duty. I am having as part of friendship. I gave gold chain for my friendship. That's it. Criminal breach of trust means when you are having control over it. Suppose a bank manager, he's having control over the checkbooks and all the stuff. Okay, then if he does something, it will be criminal breach of trust. Okay, when you are under an employment and due to that employment you get control of something, and then you, like a CA, like a lawyer, like a doctor, we have confidential documents and we misuse them. That is called a criminal breach of trust. Okay, or a policeman, he is arresting someone. When he arrests someone, he confiscates his mobile phone and wallet. Now he steals the money or he steals the mobile phone. That is called criminal breach of trust. Okay, because you got control of the property not because someone else gave you, but because this is part of your job. That is called criminal breach of trust. Unless there is an entrustment, that is why we call trust, because someone gave it to you in trust. Unless there is an entrustment, there can be no offense under this section. Example, in-laws holding stridhan for the bride amounts to entrustment of the property. Stridhan of the bride means whatever money or gold the bride brought with her. So bride brought a lot of gold or ornaments with her, and she handed it over to the in-laws for safekeeping, that you take care of my gold. In-laws said you give the property to us, you give the gold to us, somebody will steal it from you, and she gave it to the in-laws. as a trust, that I trust you, and then they misappropriate it, they sell it, that is called entrustment of property. And if they misappropriate or convert it for their benefit, this section will apply. Ministers are entrusted with equitable and generous distribution of government's benefits to people, and any breach of such entrustment would be an offence under this section. Explanation 1 and 2 about employer being entrusted with employees' provident fund, pension scheme, etc. deducts the state insurance from employees' wages and never submits it. And if it dishonestly misappropriates it or use it, it will amount to offense under this section. Okay. Now, minister does something, he is guilty of this section. If someone is abusing the provident fund contribution of his employees, then also he is guilty under this section, that is criminal breach of trust. Now we go to next section, that is cheating. Okay, that next and the last section of this section, this particular subject, that is called cheating. This section 420 you must be hearing a lot of time in your local language also. We people call it either that he's a cheat, he's a 420 and this and that. Why do we call it? Because 420 provides punishment for cheating. Okay, cheating. So we call a cheat a 420 because 420 is the section which provides punishment for cheating, and section 415 is the section which defines the act of cheating. 415 defines what is cheating. 420 provides the punishment for cheating. If someone has committed a cheating, what should be the punishment for that person? Now let us read what is cheating under section 415. Whoever, by deceiving any person, that means you are deceiving someone, you are committing fraud. Whoever, by deceiving any person, fraudulently or dishonestly, induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were so not deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property, is said to cheat. A dishonest concealment of facts is deception within the meaning of section. So this is a very big section, but I'll give you a clear understanding of what the section is saying. It says, that is the most simple way. It says one deceives someone in such a manner to make him deal with his own property in such a way which he would not have done otherwise. Okay, someone has deceived me in such a manner that I am using my money in such manner which I would not have otherwise done. Okay, I have a laptop. Someone says this laptop is wrong, there is something wrong, I must repair it and this and that. And now he has taken my laptop for repairing, and he has taken the motherboard and put some counterfeit motherboard into my laptop. Now that is cheating. If he did not tell me, if he had not deceived me by saying my laptop is not functioning properly, motherboard needs to change, I would not have definitely given my laptop to him, isn't it? Someone comes to me and says, you give me 20 lakh rupees, I'll get you a job. I am desperate in need of job. I somehow arranged 20 lakh and gave him 20 lakh rupees. Now he has run away. I would not have given him 20 lakh rupees, isn't it? Simply, why would I have given him 20 lakh rupees if he did not deceive me? Okay, so someone is deceived in such a manner, okay, that he delivers any property to any person. Okay, I will deliver my property to any person upon his asking who has deceived me. Or consent that any person shall retain any property. Or if my property is pending, if my property is someone with someone, I will give a consent that you keep my property. Okay, you keep my property. Or intentionally induces the person so deceived to do or omit to do anything to do something or omit, or not to do something which he would not do or omit otherwise. That is called cheating, deceiving someone fraudulently. Okay, now let us do some examples and we will understand cheating in a wholesome manner. A is a person by falsely pretending to be in the civil service intentionally deceives Z. Okay, A by falsely pretending to be in civil service intentionally deceives Z and thus dishonestly induces Z to let him have on credit goods for which he does not have mean to pay. A is cheating. A says, I am a civil servant. Z is a shop owner. You give me something, I'll pay you back. He believes that he's a civil servant, definitely he'll pay back, and he wants to have good friendship with a civil servant, isn't it? But he's not a civil servant. He cannot pay back. A is cheating. Simple. Otherwise, if he was not a civil servant, then definitely he would not have given him property on credit. But he pretended to be it, and because of this deception only, he gave the property. A. By putting a counterfeit mark on an article, intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer and thus dishonestly induces Z to buy and pay for the article. A is cheating. Now, A brings up a painting and says this painting is 400-year old. It was painted by the legend Pablo Picasso. Okay, and so you should pay me 20 lakh rupees for this painting. And ultimately, the painting is worth rupees 2000 only. And he has counterfeited signature of Pablo Picasso on the painting, which leads the person who is a collector of art to believe that it is actually a Pablo Picasso or MF Hussein painting, and he makes the payment. So that is a cheating. A by exhibiting to Z a false sample of an article intentionally deceives Z into believing that article corresponds to the sample and thereby dishonestly induces Z to buy and pay for the article. A cheats. Now A shows him a sample and says the bulk corresponds to the sample. Okay, we discussed in the case in Sale of Goods Act as well. A shows him some sample that this is the sample is of A grade quality and he says the bulk is also of this quality. Z buys the bulk turns out to be of bad category. Now that is cheating. A. By tendering in payment for an article, a bill on house with which A keeps no money. Okay. A. By tendering in payment for an article, a bill on a house with which A keeps no money, and by which A expects that bill will be dishonored, intentionally deceives Z, and thereby dishonestly induces Z to deliver the article, intending not to pay for it. Okay. Now A buys something from Z and says that you bill it on this house and I live in this house. And ultimately, when Z will go to that house with the bill that this is the bill on your house, the house will say we do not know A. And A knows that money will not be paid to Z ultimately. He is not deceiving him, and that is cheating. A by pledging as diamond articles which he knows are not diamonds. Intentionally Z deceives Z and thereby dishonestly induces Z to lend money. Now A goes to the money lender and says, see, I have some great diamonds. You keep them and give me whatever money. And then I'll come back and repay and I take my diamonds. They are genuine, authentic diamonds, rare diamonds. Z believes him and Z lends the money. But these are not diamonds, they are just mere stone, some other stone, cheap diamond. A is guilty of deceiving Z here. A intentionally deceives Z into a belief that A means to repay any money that Z may not lend to him. A intentionally deceives Z that I will repay your money, which otherwise Z would not have lent it to him. But Z lent the money believing that he will repay it. Z, A not intending to repay, A is committing cheating. A intentionally deceives Z into a belief that A means to deliver to Z a certain quantity of indigo plant which he does not intend to deliver, and thereby dishonestly induces Z to advance money upon the faith of such delivery. Now we have these things, isn't it? Someone will call you that you have won the iPhone or you have won the Jeep car, but you must pay 1 lakh rupees or you must pay 10,000 rupees in this account and then you will get this lottery and so on. This is what this example is. Okay, he says, I will deliver you some indigo plant, but I do not have the money. You pay me some money and I'll deliver it to you. Okay, and he gives the money. That's called cheating. A intentionally deceives Z into a belief that A has performed A's part of contract and made with Z, which he has not performed, and thereby dishonestly induces Z to pay money. A says, I have done the work, but he has not done actually, and he takes the money. That is also called cheating. A sells and conveys an estate to B. A, knowing that in consequence of such sale he has no right to the property, sells or mortgages the same to Z. Now A has sold his property to B. A again sells the same property to Z, which he has already sold to B. When he has sold the property to B, he has no right over the property, but he again goes and sells it to B and Z and takes the money. Now he has committed cheating with Z. He has committed the cheating with Z. So these are the cases whereby cheating can be committed. Okay. So with this, our portion of criminal law is complete. I hope you had a good time learning criminal law.